What is the fate of a baby mama and her child in the hands of the wife, that is madam, if the baby father died without a will? Does this smell like trouble to you or wahala, as we say it in local parlance? Truth be told, it is rarely ever a peaceful situation. Come to think of it, who should advise the baby daddy to make his will in this kind of a situation? Can we say that once the wife finds out about the baby mama and her child, she should prevail on her husband to make his will or trust to secure herself and her children? Or is it the place of the baby mama to compel the baby daddy to make his will so that she can protect her child too? Long and short of the matter is that the baby daddy should not die without planning his estate. He should decide in his will or trust how his properties should be distributed when he is no more. Now back to the matter. What happens if the baby daddy dies without a will? What do you think is the fate of all the children? I mean, both the baby mama's child and the children born by the wife in the marriage. Let me remind you once again that where a person dies without a will, he or she is said to have died intestate. Thus, his properties will be distributed according to the laws of intestate succession of the relevant state or custom where applicable. Now, the question to ask is, what does this mean for the baby mama and her child, as well as the wife and her children of the marriage? As for the baby mama, she has no claim as of right to partake in the estate of the deceased baby daddy. Now, let us turn to the child of the baby mama. What is the place of this child? It will interest you to note that the law gives this child equal place as that of the children born in the marriage. I am not the one that said it. It is what the law says. Now, here is what the law says. Section 42, subsection 2 of the Constitution of the Federal Republic of Nigeria 1999 as amended provides, no citizen of Nigeria shall be subjected to any disability or deprivation merely by reason of the circumstances of his birth. Based on this law, children born out of wedlock are treated as legitimate for purposes of inheritance. It is important to point out here that for such a child to inherit or partake in the distribution of the man's estate, the man or deceased must have acknowledged the child in his lifetime. So which means that he must have accepted and treated that child as his own in his lifetime. So you, our wife, that is feeling entitled to share all the properties with your own children alone, you are mistaken. If your husband has acknowledged that child in his lifetime, you better appeal to daddy to do the needful in his lifetime and save yourself the trouble. As per our baby mama, let your baby daddy do the needful too. You see? As for the wife, I believe there is nothing to worry about if the deceased husband left a will. However, if he gave you little out of surplus, you are to answer the question, why so? Nevertheless, if he died without a will, the wife has priority over every other person on the list, as she is usually the first in terms of who can apply for letters of administration to administer the estate of the deceased husband. Please note that the law also recognizes the rights of some other members of the family to join in the administration of the estate of a deceased husband who died without a will.